Recognize Chairman Ellis from the Senate TRW Committee. Thank you for being here. Let's go ahead. Before we do roll call, I'd ask Chairman Flitner if she's got any comments. So if we could do roll call, Mary Lee.
Representative Kinner.
Here.
Representative Larson.
Here.
Representative Schwartz.
Here.
Representative Simpson.
Here.
Representative Stith.
Here.
Representative Walters.
Here.
And Chairman Nicholas. Perfect timing.
We good, Miss Mary Lee? So with your permission, Chairman Flitner and Chairman Nicholas, perhaps we could have Chairman Ellis, if you'd come up and participate with us and kind of take us through what you guys done with Senate File 56. And Chairman, if you wouldn't mind, would you kind of remind us as we reflect back on the bill we passed last year, House Bill 171, kind of how that ended up, and as a benchmark for where you start your discussion this year, please.
Absolutely, Mr. Chairman. Well, welcome, or thank you for welcoming me, House committee members, and I apologize to new members of the newly elected members to the Travel, Recreation, Wildlife Committee. I haven't met many of you, so if I don't get your name right, my apologies. I need to make my way down the hall and introduce myself. I am excited to talk about this issue, and just to give you a little bit of background about kind of get you up to speed on why I've been spending so much time on this particular bill. Early on in my career, I spent some time working in Washington, D.C. for former U.S. Senator Craig Thomas. It was my first job out of college, had a really great experience. But while I worked for Senator Thomas, I had the opportunity to work for an agency called the National Indian Gaming Commission. And it's a federal regulatory agency in Washington, and it oversees Indian gaming nationwide. And in the brief, I worked there less than a year, but was exposed to the Indian Gaming Regulatory Act. And I can tell you that the issue that we're talking about today is not unlike some of the challenges we saw when Indian gaming was really coming off the ground. A lot of confusion about whether a certain machine is a class 2 or class 3. And depending on the internal mechanism of what's happening in the machine, it's either class 2 or class 3, and those are regulated differently. So when it comes to these skill-based games that we're talking about today, I want to be clear that you may have some experience. Maybe you've seen a historic horse racing machine, a skill-based machine, and you might think this looks like a slot machine. I can tell you that the mechanics of what's happening inside, though, are very different. And that's something that Wyoming's got a lot of work to do to understand. So with that kind of prompted the reason that we had House Enrolled Act 95 last year. You had a number of these machines in Wyoming, and there was great concern over how many, where they were, how much money was being put into them, how much was being paid out. And I think that there was a lot of concern about just not knowing what was happening inside these machines. So it prompted the legislature to look at the existing parimutuel commission, which has typically looked at horse racing and more recently historic horse racing machines. And it transformed the parimutuel commission into a gaming commission. And so as we walk through the bill, if you're familiar with this act, I should have sent you guys a summary, but the bill contains a lot of codification of that law that we passed last year. And so I've sent all the House Appropriation Committee members a copy of Senate File 56. And in the margin, you'll see my notes that say codification. And so really, that's just putting into our statute books what we passed last session. I also put some conforming amendment indications in there so you can see where we're just doing some cleanup. But I also highlighted areas where the Senate added some bigger concepts and reflected some changes from the session law. And before this bill continues to move forward, I will email that copy to House TRW members as well. And so last year was an important year for the Gaming Commission, and it's always hard to stand up an agency like this. We're playing catch up a little bit, but we know a lot more today than we did last year. For example, the commission was directed to provide a Wyoming Gaming Commission study, which I know the TRW looked at during the interim. And you should know that I did not serve on TRW last year. So a lot of my work has come from talking to previous members who served on that committee and reading minutes and doing all that kind of catch up. But what we know today is that in Wyoming, there are about 306 statewide locations that offer these skill-based amusement games, and there are 836 terminals. The report talked about that from May 11th, 2020 to August, net proceeds for these games has been over $3.8 million, which translated into a $763 tax that the Wyoming was able to recover. Since that number of August, or excuse me, since that date in August to date, I understand that's more like $2 million. So these games are certainly creating some revenue for the state. So with that, when I first started looking at House Bill 56, coming out of the interim, we had a hearing
Chairman
on it.
Ellis.
Oh, yes, Senator, or excuse me, Representative.
So as we get started on that, just to rehearse and correct me where I'm missing the point. Last year, the concern was we've got skills game. Certainly was a broad interpretation of skills games, whether they were slot machines or whether they weren't. And so as a conclusion, as we've ended up, we says, okay, we're gonna keep skills games and we're going to make them legal for this year. And here's a process that you have to go through. They had to be registered, then they had to have a stamp, and then we defined where they could be. Correct. And then we put a sunset date on that said June 30th of this year, 2021. If nothing changes, they all go away. Correct?
Is is it Vice Chairman?
Doesn't matter.
Correct, with a caveat. So the session law required that vendors, and this is kind of a new term that we're introducing through Senate File 56, but basically the person who's in charge of the game is the vendor. And then we also put some requirements on the establishment, or now we're going to change it to the owner of the establishment, just to make that clearer. And so if you were a vendor that's in more or less in control of these games, you had to apply for a license through the Wyoming Gaming Commission. Similarly, if you were an owner of an establishment, a bar, a restaurant, some kind of place, you also had to seek licensure from the Gaming Commission. And the caveat that I'd offer is the understanding was that it would be a 1 year kind of look at what was happening and authorizing these games to be in Wyoming for 1 year. I think there is a little confusion about what happens if we don't act on this. I think some people might have the expectation that these machines will go away. People will pull the plug and get them out of the state. But I think there's another school of thought that says, no, I think it goes back to being the Wild West. We don't know how many will come in. We don't know where they'll be, and we'll be back to where we are. So I don't want to offer my opinion one way or another, because I think we'll see probably both interpretations out there in practicality. And so I think that kind of hits the point of why this is really important. If we don't do anything this session, we're going to be starting all over again. And the concerns about where they are, what's happening, they'll continue to persist. So with that, just a little more history. So during the interim, right before the virtual session commenced, we had a version of Senate File 56 before the committee. And, recognizing that I had not served during that interim, I wanted to step cautiously and really tried not to offer too many amendments. But after we got done working the bill and decided to advance it out of the committee, I listened to a gaming commission meeting that was held that same week. And after the call, I received a phone call from a gentleman in Park County who had some concerns. There were 6 denied applications, and his application was one that was denied. And so I visited with his attorney, learned more about the case. I contacted the Gaming Commission. They told me about the 6 applicants they denied. And so I did a lot more research on the other 2 applicants, one in Campbell County and one here in Laramie County, actually in my home district. And so, I want to be clear that this is difficult. We're doing our best on all sides, as a legislature, as an executive branch, and as an industry. But I think that if we adopt some of the measures contained and proposed in Senate File 56, we're going to really provide more clarity so the Gaming Commission knows what our expectations are. And then we'll provide a little bit more clarity for industry so they're not having to struggle through some of this lack of clarity. So with that, Mr. Chairman, I wanted to just kind of walk you through the bill. Are there any questions before I start doing that?
Members, any questions? Which are we going to go through the blue version?
I think the engrossed version would be appropriate.
Any questions for Chairman Ellis at this time before we start down the road?
All righty.
Okay, proceed, please.
Okay, so looking at page 2, here's where you're going to start seeing codification of existing law. And like I said, I mentioned to all of you, I emailed you copies of my kind of notes. I had some suggested amendments. I believe Representative Walters will bring those to your attention a little more forcefully. But here you're going to see the creation of 1125-301, which provides for the authorization of skill-based amusement games and the commission's authority. So paragraph A talks about how those games that were operating in accordance with the 2020 Wyoming session laws would be those that are authorized. And that's kind of your grandfathering clause. As we understand it, we could provide some more clarity in there, but the idea with the original legislation and as industry understood it working in the interim was we were kind of capping it at that March 17th date, of last year, which was when the session adjourned. And so if you wanted to allow new applicants, we would need to probably look at some of the language here in this paragraph, but that's codification more or less of the session law. On page 3, paragraph B, you're going to say that any skill-based amusement game that meets the requirements of this article be approved by the commission in the state, or it shall be removed by the vendor. And then section C talks about the commission having the ability to promulgate any necessary rules to administer and enforce this article. You should know that all the language on page 3 is all codification more or less of the session law from last year. Moving on, here's a really important part of this bill and has been a source of contention in the litigation that I mentioned for 3 of the denied applicants. This talks about a laboratory report. And so you'll see section A requires that each vendor shall provide for a nationally recognized independent gaming lab approved by the commission to submit to the commission a general functional evaluation laboratory report regarding the software installed on each of the skill-based amusement games, indicating whether the game is in compliance with this article. So talking about the litigation a little bit, there's some confusion about whether or not the commission can deny a recommendation made in a lab report. And my view, and I think the view of this, the plain language of the statute is because these games are new to Wyoming, we don't necessarily have the expertise. So we want the commission to really rely on these reports. Going forward, I think it's appropriate for us to have the discussion about allowing the commission to promulgate rules. And if they're going to deny an applicant based on an element that's in the report, that be clearly identified in advance so that people know the rules and that those apply to everyone. But as it stands right now, I think that this language is sufficient. I think we should leave it alone. And, to me, it's very clear that we want the commission to rely on those reports heavily. I would call your attention, though, to line 18. It says that the report has to be submitted directly to the commission from the lab. That's also been a source of confusion in visiting with the people who brought this bill. The reason that we're directly in there is out of a concern that the lab report may be altered or somehow tampered with. And so you'll see later on in the bill, we added some language that any person that falsifies, omits, or tries to tamper with those reports before they submit them, that would be grounds for denial. But as a practical matter, if you're an applicant, you'll see these applications are expensive. You have to spend a couple $1,000s. You would want to see what your report says before you send it to the commission, right? Like if you get a report that says, we don't think your games meet the definition, you probably wouldn't want to spend that money to apply. So I think removing that word directly on line 18 is probably a very important change. Moving on to page 4, you're going to see a new language starting in paragraph B, lines 4 through 9. And this says any alterations, modifications, or updates to the software or hardware of any skill-based game shall require the vendor to submit to the commission a new lab report before the game may be used. And so during the interim, there was a lot of discussion about what the report should include, but it seemed very technical. And I can tell you that technology changes, and it just didn't seem like quite the place to have that really prescriptive language. So if you went back and looked at the language that was included during the interim, you're going to see we cut most of that out. But I think this is sufficient, and industry can attest to this, that this requirement wouldn't create a new burden and has been generally agreed upon by industry and others concerned. Moving on to the bottom or the rest of page 4, this is more codification of the existing session law. And here's how you're going to see some restrictions. And these were really important, I can tell you, in my chamber, that no skill-based amusement game can play, no skill-based amusement game shall allow a game play of more than $3 per play, and that they cannot pay out more than $3,000. No establishment shall have more than 4 skill-based amusement games operating for play at any one time. And so in the Senate, and this is kind of a good time to kind of talk about what's going on with these machines. In the Indian gaming context, the line between what's class 3 and class 2 all depends, as I mentioned, on the internal mechanics of what's happening in the machine. Your casino style slot machines have something called a random number generator that's inside the machine. And so really you have, in theory, an infinite number of possibilities of what could happen or the outcome of the game could be. For class 2, and again, this is in Indian gaming, they want a predetermined outcome in the machine. So these skill-based games are a little bit of a different animal. But if you think about a video game or an arcade game like Pac-Man, you know that you're moving a joystick and there's an element of skill in your play. So if you think of these games more like an arcade game that actually has a payout, maybe that helps you understand what it is. And so in the Senate, a big part of the concern is, are we allowing citizens of Wyoming to gamble away mortgages and college savings and things like that? This check is a really important one because you would have to sit at a terminal for a very long time with $3 per play, with your max reward being $3,000 to really kind of get in that kind of jeopardy. So I can tell you that that's a key part for the Senate in ensuring that we're not creating a situation where people are making those kind of risky wagers. Any questions about that with the skill-based games?
Mr. Chairman, not a question, but just to add on to Senator Ellis's comments there.
Go
Really,
ahead.
thank you, Mr. Chairman. We put that in a year ago, knowing that keeping the max amount to play and the max reward low has been shown to limit problem gambling, just because if you can't win a lot, you don't get as excited about it. And that keeps these games at an entertainment basis as opposed to a destination for gaming basis. And that was, I think the Senate is right to be concerned about it and think really can agree with this language, and it is important. So glad that you pointed that out, Senator.
And anecdotally, if you talk to the players, I'm not a gamer. I don't like to gamble. So I was a good fit for the Gaming Commission. But
Please proceed.
anecdotally, I think if you draw the comparison of, if you go to a restaurant and you see, again, an arcade machine and you toss your kid $10, they're going to spend that money. You're comfortable with them having the value of having that play. That's how I think Wyoming should be kind of viewing these games as something just that people can do for entertainment and as an enhancement for local businesses, bars and restaurants and things like that.
Chairman Flitner.
Yes.
Mr. Vice Chairman, thank you. And Chairman Ellis, just off the top of your head, how many independent labs are functioning within this business?
Thank you, Mr. Chairman. I don't know the answer to that. And I can tell you in doing the research, and I've done a lot of work to try and get up to speed, there are some gaming commissions in our country that actually have really prescriptive rules about whether or not they're going to allow a gaming or a lab to be utilized or their reports to be utilized in their state. I think it was Ohio, they actually require information about the directors of the labs and their financial history before they'll approve them. So I think that that's another thing that we can think about going forward is what kind of look do we want the commission to have when it comes to whether or not they're going to approve a certain lab. I think there are at least 5, but I don't know that for sure. And just kind of a preview of things to come. I think we as a state and as the commission, we need to start harmonizing how we view these games because to the consumer, they look very similar, but we'll have to do a better job of understanding the internal mechanism of what's inside a horse racing machine. Those are all based on historic races. And so there's a finite number of outcomes within that machine, but it's a bit of a random issue of what kind of response from the race you're going to get. And so I think that'll be work that the TRW will hopefully undertake in the 2021 years to make sure we all have really clear definitions and know how these games are similar and how they're different and making sure that it all kind of works out.
Mr. Chairman.
Representative Stith.
Senator Ellis, thank you. I just want to back up a little bit back to page 4 and it looks like there was an amendment over on the other house. What was page 4, lines 8 through the remainder of the page and then over onto page 5. Looks like that got deleted in our gross copy. That relates to, I guess, when there's an update to the software, the criteria you use. So what was the thinking on the other side by you all of why you thought it made sense to delete that, if that's what happened?
Chairman Ellis.
Thank you, Mr. Chairman. The reason, and I mentioned it briefly when I was going through the bill, it was, we thought, a little too prescriptive. And I think we need to be sensitive because it is gaming. And, I think there is always going to be the concern that somehow whatever we write or whatever we do is written to benefit maybe one particular manufacturer or vendor of a game. And so in my view, I was a little nervous that that language may have been, could have been used to fence out other potential manufacturers. And so in visiting with industry members, it was what's the intention that we're trying to get after here? And so instead of having really prescriptive language baked in our statutes, we thought taking it and making it a little bit more broad would be a better approach.
Good. Any other questions? Thanks. Chairman Ellis, please proceed.
Okay, we're going to get there.
Yes, we
So we're
are.
on page 5, and then here's more codification of existing language. In paragraph D, it talks about the operator not locating a skill-based game in an area where it's really restricts it to areas that are limited to 21-year-olds. And it requires that the operator of the establishment conspicuously mark each area of the establishment containing those games in those age-restricted areas.
Mr. Chairman.
Go ahead, Representative Schwartz.
Thank you, Mr. Vice Chairman, actually. Madam Chairwoman, last night we were dealing with sports betting and the age we used was 18. I recognize this is existing language, but was there any discussion? Because obviously in a bar, it would have to be 21, but they don't have to be in a place that serves alcohol. Was there any conversation about the age?
No, Mr. Chairman, Representative Schwartz, there was not.
Thank you. Please proceed.
Okay, and so then we're going to go on to the creation of the new 1125-304, and this talks about your taxes. And so once a machine has been approved by the commission, it says the operator shall be issued a permit and be required to pay an annual fee of $250 to continue to have the game operating for play in the operator's establishment. This language is a little different. If you went back and looked at what we passed in the session law, and I'll talk about it when we get to the definitions, we are inserting, I think, clearer language that talks about vendors of machines versus owners of establishments. So you're going to see that language reflected there. But it also talks about operating for play. And we changed that because if you read the initial language, it limited it to 4 machines per establishment. But you can imagine a situation where maybe a certain machine breaks or is in transit, and for whatever reason an establishment has more than 4. We don't want to penalize those people and remove their gaming license. We want to recognize that it's for play. That's the limitation. So that's why we made that change in that paragraph. Romanet.
Madam
Yes.
Chairman,
Mhm.
so is that $250 blanket permit for the total quantity of skill games, or is that per skill game,
That is per establishment.
per establishment?
Yep, we set up, and you'll see it on the next page,
Thank
a
you.
different amount per machine.
Thank you.
Mr. Vice Chairman.
Please.
Thank you, Mr.
Pat,
Vice Chairman.
Go ahead.
So just to back up, Madam Chairman, so did truck stops get taken out, or did they appear later in the bill?
Madam Chairman.
Mr. Chairman, there's no specific mention of the word truck stop. And I don't know of all the terminals that were approved and the locations that were authorized, if there are any truck stops that meet that requirement of having a fenced off area of 21 or not. I don't know the answer to that. That might be a good question for the commission.
Thank you.
Mr. Chairman, to help answer that, all of the language about location was taken out and turned into a generic description of games operating at the state in the state at that time. There was an early version in the House of this last year that talked about linking these to liquor licenses, and truck stops were defined and all of that, but all of that language was removed. So currently they can be anywhere as long as they were in the state prior to March 17th, and then in a fenced off area delineating a 21-year age restriction for that area of the establishment.
I believe, Representative Sweeney, your recollection of that is accurate. It was in one version of the bill that we passed, but I think at the end of the day that was fell by the wayside. Please, Madam Chairman.
Okay, and so then going on to Romanet 2 on the bottom of page 5, this talks about the vendor license. Going on over to page 6, you're going to see that that's a substantial license cost. It's $2,500. And so that's why, members, I'm pretty adamant that that word directly be stricken on page 3, line 18. Simply, if you were the vendor and you got your lab report, you'd want to make sure you read that report before you submit your application to the Gaming Commission. It's a substantial fee. On to
Well,
paragraph.
Madam Chairman, but wouldn't it be fair to say that just because you submit the lab report doesn't require you to pay the $2,500? The $2,500 is when you receive the permit. And so if you got the lab report and your machines didn't pass, you're not out anything. Am I misunderstanding that?
So just to back up, Mr. Chairman, I think you're correct, but it's more just a practical matter. If you're the vendor and you hire a lab and those reports are expensive, that lab would be required to submit to the commission. You could also request a copy and look at it, but then you kind of got this lab report out there that the commission might receive without an application. And so I actually did a review of all of our statutes to see if we require this directly submitted to any entity. And we don't do that in any other context. We don't require lawyers to submit filings directly to a court. I mean, it just creates, I think, confusion. The purpose of having the word directly in there was to get after the fact that we don't want people tampering with the reports, omitting parts of the reports. And so you'll see language later on through an amendment that really makes it clear that any of those activities that what we're really trying to prevent would be automatic grounds for denial. So the applicant, in theory, could take their lab report once they've had a chance to review it, their $2,500 check, send that all to the commission. And if the commission wants to verify with the lab the accuracy of the report, that's a great check.
Well, but we do see that in drug testing where it goes directly to, I mean, that isn't charting new ground. It may be inconvenient for the operator. And I think the discussion is certainly for us to have. Do we want this? Do we feel that this really is an inconvenience for the operator, or does it protect the integrity of the report? Correct, is what we're saying. And if I understand you correctly, you feel that you have some side guards later on in there to protect the integrity of it. But I think it would be fair to say that in other situations that we currently have, and I just use drug testing where, you know, I go and get a drug test. I can't take that drug test back to you're out of here, man. We'll send it to whomever that belongs to, but you don't have any say in it from that point on. You'll get a copy. So it's not totally unprecedented. We just need to decide how cranky we want to be. Is that?
Mr. Chairman, I can tell you that word has caused a lot of confusion in the litigation.
Okay.
And that's the reason why I feel like if we took it out, it would clear up a lot of that confusion over what does directly mean? Does directly mean the lab has to drive it from their possession to the commission? Does it mean that, you know, you put it in the mail? I mean, they're just, if you wanted to really mess with what that means, I think you could. And I think that it's not achieving what we're trying to get after, which is the validity of the report.
Please proceed.
Okay. On page 6, you're going to see, again, this is all codification of existing language. On subsection B, this talks about the decals that are 1-year decals that have the bucking horse bronco. They are $50 each, and this is where it's the per machine charge. Moving on, section C, this is talking about the fees being required, and this is slightly different than the session law. During the session law, we had some different language about how those dollars should be allocated. Again, we weren't sure how many machines were there. You know, we wanted, I think, the Gaming Commission to be self-funded. So this kind of recognizes that. We do know that now. And so it says the fees that are paid under subparagraphs A and B of this section are deposited into the Gaming Commission account, which now is created. And then funds within the account are continuously appropriated to the commission to pay for reasonable expenses incurred to administer this article. And later on in the bill, you'll see where the allocation of the revenue for the taxes comes in. But the fees, we just made some clarifying language to update it. Any questions? Alrighty, then here's section D, talking about the taxes. These are to be calculated and paid on a weekly basis based off the net proceeds entered or earned during the prior week on the skill-based amusement games. And then on a weekly basis, the vendor is to remit to the commission an amount equivalent to 20%. You're going to see some new language though on line 5 and 6. It says the taxes imposed under this subsection may be prepaid as provided by rule of the commission. This new language was inserted at the request of some in industry, and I'll let them explain it a little bit more. But I believe the theory is that they fill the machines, and so they wanted the ability to prepay and do some kind of true up with the commission after the fact. The commission didn't feel like they had the authority to do it otherwise. This would allow them to do it, and they didn't express concern that they would be incapable of allowing for prepayment as a matter of logistics. They were just worried about their authority to do that. But I'll let industry answer that if you have a burning desire to know why. And then here's the distribution of the tax. 45% to the county and city or the town in which the game is played in equal shares, or to the county alone if it's not located within a city. Again, this is codification. And then 45% to the school foundation program. And then finally, this is a new concept. Again, this would allocate 10% to the Wyoming Gaming Commission account. We did get a question on the Senate side about whether or not this amount was enough, too much, or just right. I think 10% for the time being is a really important placeholder. We do want this commission to be self-funded. And at this point, we're going to have more conversations too about what the needs are to ensure the adequate regulation. Do they have enough investigators? Is there more law enforcement or those kind of assistance that we need to provide? And so I would, if your body has any urge to tinker with that amount or reduce it, I would just urge caution, because we want to make sure that we're giving this commission the tools they need to do their job. Okay.
Did you have,
Mr. Chairman.
did you have revenue dollars and breakouts for how much has coming into the commission? Because we funded them with a certain amount of dollars, and then what the balance of their accounts were and that type of thing.
With respect, Mr. Chairman, maybe that's a good question for the commission. Okay.
Proceed.
I
Go ahead.
I did have one other question on this particular entity, because it looks like the county's, it's kind of a win-win for them. If it's in a city, the county gets half. When it's out, not in the city, the county gets all of it. And I'm just curious if you had any discussion on that, because it seems to me that if you're in a city, it would mainly primarily go to the city, not the county.
Mr. Chairman, we did not discuss that in length at the Senate side. This was a codification of the session law. Okay. Moving on to page 8. This is a new section that we worked on and that I really feel very strongly about. But this talks about the criteria of approving licensure for the establishment permits and the operator licenses. And so we adopted this on a second reading amendment in the Senate, and it says that the commission shall not more than 60 days after the date of receipt of an application or for application for renewal of an operator permit, a vendor license, or a skill-based game decal, that the commission shall either issue the permit, license, or decal, or deny the application based on grounds that the applicant failed to qualify as provided by subsection B of this section. So this talks about automatic grounds for denial, and this is kind of what states do. And to ensure the integrity and make sure that we're not just giving licenses to people with serious criminal records. And so it says the commission shall deny an application under this article if the applicant has been convicted of, forfeited bail, or pleaded guilty to any of the following. Going on to page 9, a crime of theft, a crime involving theft, dishonesty, or fraud, bribery, or unlawfully influencing a public official, a crime involving physical harm to an individual, or any other crime identified by the commission rules. And since adopting this language, I have heard some concerns by members of industry and applicants that we might have some tinkering to do with this particular language. So going back, talking about the applicant having been convicted of, forfeited bail on, or pleaded guilty to, we might want to limit that to maybe a 10-year look back, because the example was provided that what if you have a person who's 50 years old but had a shoplifting charge from when they were in college? Do we really want to limit that person's ability to engage in this activity? So I think by providing a 10-year look back, that's a sufficient, it should hopefully, address some of our concerns. However, I do think that the commission should be able to look back further and address those instances on a case-by-case basis. But this particular section deals with automatic grounds of denial. So I would ask if you were to seek an amendment to maybe add some limitation to that, just to make it a little bit more workable for our applicants in Wyoming.
Madam Chairman, when going back to the requirement on the commission to not take more than 60 days, do you have a feel for what the average time has been for a vendor to get a permit from the commission?
Mr. Chairman, that 60-day requirement is from session law, and they were able to comply with that, to my understanding.
Okay.
Going on to,
Mr. Vice Chairman.
Representative Sweeney, please.
Thank you, Mr. Vice Chairman. So, Chairman, in that, item C, page 9, line 7, so a crime involving physical harm to an individual. So they would specifically say you're an owner of an establishment, you had an unruly patron, and you were involved with a bar fight, and the owner of the establishment is being sued, wasn't necessarily arrested over the deal, but is that, I'm not an attorney, so is that involvement a crime? Does it rise to the level?
Sure, Mr.
Madam Chairman.
Representative Sweeney, you're reading my mind. So going on to page 9, my next comment of a suggested amendment that you might want to consider is on line 7 and limiting that to a felony crime involving physical harm to an individual. And so this is a pretty serious charge. The concern was raised that if you have a bar owner that had to get physical with an unruly patron, they might be facing some assault charges. And so my understanding is that those are usually misdemeanor assault charges. They don't rise to a higher level. And so we want to make sure that we're not, limiting their ability to get one of these licenses. So I think by inserting the word felony, that you're setting a pretty high bar. And what we're trying to prevent is kind of that mafia muscle from people that have really serious criminal records with physical assault charges like that, aggressive behavior. We don't want those folks applying for licenses. And then to your point about being sued, we'll talk about civil instances later on. We've got a provision that kind of covers those instances too. Any other questions? Okay. And then the last thing I would say is subsection D, lines 10 and 11 on page 9, maybe adding some limiting language there as well, saying any other crime identified by the commission which would adversely affect the credibility, security, integrity, or fairness of play with skill-based amusement games, just to make it clear that that's our intention, that we want them to be tied with the activity of dealing with the skill-based games. And so here on line 13, paragraph 2, you're gonna see that language that I talked to about let's get rid of the word directly. Here it says the applicant, this is an automatic ground for denial. The applicant concealed, tampered with, failed to disclose, or otherwise attempted to mislead the commission with respect to any material fact contained in the application or contained in any other information required of or submitted by an applicant to the commission. And so, Mr. Chairman, rather than have that word directly, I think this makes it much clearer. And then the penalty is severe if you omit parts of your lab report, but it's also broader. I mean, if you're not keeping the commission apprised of anything that they need to know about, you could have your license revoked or suspended. So I think this is a much better approach than having that kind of ambiguous word of directly in the other part of the statute.
Mr. Chairman.
Representative Stith.
Senator, going back to this issue of the word directly, I guess I'm really it sounds like you're advocating that we delete the word directly. And I'm just having trouble understanding why we would do that. I mean, when you apply to become a member of a state bar as a lawyer, you have to prove, unless you're in California, you have to prove that you graduated from a law school. And the state bar doesn't accept just your word for it. They don't even accept just your transcript. They get the transcript directly from the law school to prove that you actually went there and actually graduated. And I don't think anyone thinks it's particularly ambiguous what that means when you have to get your transcript submitted directly by the university or the law school to the state bar. And it seems to me that if I were an applicant and I had the ability to submit the application to the Gaming Commission, I'm going to get a first draft of it. And if I don't like that first draft because the first draft says something like this game has an inherent element of chance, that might be the first draft of the report. I might call them up and say, hey, I'm paying you a lot of money for this report. I think maybe you ought to wordsmith this a little bit. Instead of saying inherent element of chance, you might say something like this, no more than to the extent that chance is implied by the Heisenberg uncertainty principle, and everything that happens in the world is by chance. And this, and wordsmith it so that it waters it down so that the report says what I want it to say, because I'm paying for it. And I'm going to tell you how I want it drafted. And it seems like there's real potential for problems there, and I just don't see the harm.
But Madam Chairman, I think if I understood you correctly, I think that what Representative Stith is saying kind of leads to the issue that you have, whereas it's being interpreted that you don't get to have a chance to reflect on the report before it goes to the commission. That once the report would come out, it was being interpreted that once the lab got the report, they're required to send it directly to that, and you're not seeing anything prior to it going there. And I think that's what you're saying we're trying to get rid of, that the vendor has. We think it would be perhaps be appropriate if we can maintain the integrity of the report to allow the vendor to look at it, then maybe have that discussion back with the laboratory if he didn't like what he's seeing, or even not submit it at that point if he didn't want to. But the protection comes on there if he gets mischievous with the report.
Correct. So, Mr. Chairman, let's just remember, this is not perfect. We are doing a lot of catch up. The thing I think that the commission should think about going forward, as I mentioned, the state of Ohio has rigorously promulgated rules about which which labs they'll recognize. They ask for a lot of detailed information about who the CEOs of the lab are, who are the people doing the report. I mean, they do a background check on their labs. And so I think that the Wyoming Gaming Commission, through rulemaking, could very much put some muscle behind what they require of their labs. And so one of those items could be, and I think you're hitting on something important, was a requirement saying, did you receive subsequent correspondence from your applicants, or from the applicant asking you to alter this? I mean, there are things that they can do on the back end to check that. I'm just trying to provide a little bit more just kind of common sense for the applicant who's seeking these licenses. And to your point about law school, absolutely you have to verify you went to law school, but it's a matter of, do I need my law school to send the state bar directly my transcripts, or is it enough that I have the sealed copy, the verified version, and I put it with my packet and then submit it with my application? That's what I'm trying to get after, is that absolutely verify, but not, and just have it just be a little bit more practical. But that's something to work on. I mean, that's, in my view, I think I would love to see the commission kind of put some structure behind identifying their labs and having criteria.
So we use vendor, we use operator, and we use establishment. What's the difference between an operator and a vendor?
Yeah, Mr. Chairman, if you want to, let me see, we're going to get to those definitions. They're contained later on in the bill. And so when I first started my presentation, initially, when we passed the session law, we had operator, and that was understood to be the operator of the machine. But then we tried to regulate, and we defined establishment as a place. But then we were talking about establishments having liabilities as if they were a person. And so it was, to me, very confusing. A place can't be liable for things. The owner of a place can be. So we adjusted some of those definitions to say owner of an establishment, operator of a machine, to try and provide a little more clarity over who's got an obligation and liability.
So when you're on page 10 and you're talking about what continuing duty to disclose on arrest, convictions, guilty pleas, and civil actions brought against them, those are, well, it's interesting because on line Romanet 3, you have operators and establishments. So does that, I mean, that means anytime a bar is sued for any reason, that they have to notify the, it could be, they could be from the utilities or somebody else. I mean, it's a pretty broad definition of that requirement.
Okay, so we haven't got there. May I proceed? Or any more questions on page 9? Okay, so we're on to page 10, and Representative Nicholas is hitting on some important things. So this is all new language on page 10. It says on Romanet 4, the applicant failed to otherwise meet requirements of this article, kind of a catch-all. And then a new concept here, paragraph C, operators have a continuing duty to disclose in writing any material change in the information provided in the application to the commission. These things include changing to the names and contact information, any arrest, conviction, guilty pleas, disciplinary action, or license denials in Wyoming and other jurisdictions, any civil action brought against the operator establishment, and any other information required by commission rules. So the paragraph Romanet C or 3, excuse me, that you're talking about, this isn't an automatic ground for denial. This is a duty to disclose to the commission if you've been sued, for example. And so if you're the establishment and you had a slip and fall case, let the commission know, and they can determine whether or not that action threatens the integrity of the game. My guess would be the commission would say, no, we don't need to look at that issue. But what if you had a continuing situation where you were allowing minors in your bar area and you had minors that were playing the game? You would have a duty to disclose that to the commission, and they might want to take a closer look at what's happening at your establishment to make sure that you're following the letter of the law. So that's the duty to disclose. It's not an automatic ground for denial. It would just inform the commission. So if they needed to take further action, that they just would be aware.
And so, Mr. Vice Chair, the way you have it, this is operators have a continuing duty to report if the establishment is sued, which means the establishment has to tell the operator, because it's a duty on the operator. Is that right?
I think, Mr. Chairman, you were hitting on something important that could probably use a clarifying amendment about the owner of the establishment instead of just the establishment. I didn't catch that, but that's a good amendment.
Thank you.
Thank you for catching up. Any other questions about that section? And then on the bottom of page 10, paragraph D, this is also a new concept. This says if the commission denies an application or intends to revoke or suspend a license or permit issued under this article, it shall notify the applicant in writing, stating the grounds for the denial, revocation, or suspension, and informing them of a right to submit within 30 days additional documentation related to the grounds of denial. Once they receive that, the commission can reconsider its decision. And then this is where it can inform the applicant within a certain amount of time that the 20 days that they're not going to reconsider. And if they continue to deny an applicant, that the Wyoming Administrative Procedures Act come into play. And so for those of you who are unfamiliar, this affords the applicant some due process, a hearing, a proper notice. And this was a very important element of the lawsuits that were brought. As I mentioned, on the three applicants actually brought lawsuits because they did not receive notice as required under the Administrative Procedures Act. And there was no hearing, no formal hearing, no opportunity to present information. And so this, I think, affords them that due process. Any other questions? And this is important. You know, I don't want to point fingers at anyone. Our job today is to make things clearer for everybody involved. You know, the commission was unclear about whether or not they should apply the Wyoming Administrative Procedures Act. This really makes it crystal clear, and this is really important. So thanks for paying special mind to it.
Mr.
Chairman.
Vice Chair, so the one thing that I have a question about this is this suggests that this is the only place that the APA applies. And so any other rulemaking or some other components that they do may not be applied if you use the rule out kind of concept.
Mr. Chairman, if I flag those areas in the bill and want to offer an amendment to make it clearer for the commission that you want the Wyoming Administrative Procedures Act to apply, I think that's a welcome amendment, but I leave it to your legal mind to identify those areas. Alrighty, on page 11, you'll see penalties. This is codification of existing law, talking about anyone violating the provisions may be guilty of a misdemeanor, fined not more than $1,000, and be imprisoned for 6 months or both. And then moving on, that deals with kind of the new creation of new statutes. Section 2, these are all changes to existing law. So going on to page 12, you're going to see the definition of gambling, which is found in Title 6. And so rather than reinsert definitions, we just referenced in paragraph M on line 17 that unless activities are authorized under Title 11, Chapter 25, which is the newly created statute.
So,
And then
Madam Chairman,
Mhm.
just for me, so Title 6 is our gambling statute.
Correct. Mr. Chair,
Title 11 then is the commission and the parimutuel. And then 7 is because we're taking these definitions. I'm just trying to understand why they are where they are.
Sure. Mr. Chairman, I believe Title 11 is where the parimutuel was originally housed in the statute. Title 6, this is a criminal activity. So we prohibit gambling in Wyoming except as allowed. And so rather than say under law, then we're trying to broadly loop in. We recognize that Title 11 has some exceptions to that prohibition on gambling. And so then you'll see this reference to skill-based amusement games. Again, I would classify these more or less as conforming amendments. So hopefully we can cruise through the rest. But rather than have the definition, just refer back to the newly created definition. You'll see that on page 13, lines 5 and 6. On 7/19/106, this deals with who has the ability to receive criminal history records. And so it would add the Wyoming Gaming Commission on line 15 as an entity that's authorized to review criminal background information. Going on to 13, similar reporting requirements here in Title 7. This talks about the NCIS, I think that's the name of their database, the National Criminal History Record Information. Going on to page 13, again, this is, I count it as a conforming amendment, just saying any person who's applying for one of these licenses would be covered. Onto line or page 14, this is, again, I would call this a conforming amendment. We appointed a law enforcement officer to serve on the commission during the session law last year. And so this clarifies that when that officer is serving on the commission, that it's included in their duties. So that's the reference you'll see on lines 14 through 16. Going on to page 15, this is again another conforming amendment because it was housed in the parimutuel statutes. You'll see the definition of breeder award. We're just expanding that because we're creating new statutes. So it's got a larger, or excuse me, we moved some things around. So this definition of breeder award would be need to be reflected in a different part of the statute. Let me, yeah, correct. Sorry, same thing with parimutuel event. You'll see the change on line 22 on page 15. Going on to page 16, more similar amendments, this act, just changing the numbers. Source market fee talks about license fees, including that reference to the newly created paragraph M on line 11. But this is where we're going to get to some changes in definition that Representative Nicholas alluded to. In the session law, we define establishment means a single physical place of business. And so in the session law, we talked about establishments having duties and establishments being having duties. And a place can't have a duty. People have duties. And so then you'll see this hopefully clarifies it on the lines 19 through 21. An operator means a person who possesses and operates an establishment where skill-based amusement games may be played. And you know, the good senator, or excuse me, the good representative and our chairman here, we can tell you that person also means corporation, and it's a much broader term than that, in case that comes up during your debate. Going on to page 17, talking about skill. This was at the request of just providing a little more clarity. Skill means a player's knowledge, dexterity, or any other ability or expertise relevant to gameplay. And then skill-based amusement games means, and this is a new definition, means a game played in exchange for consideration of cash, credit, or other thing of value on a fixed commercial electrical gaming device in which the bona fide skill of the player, determined by an individual's level of strategy and skill, rather than an inherent element of chance, is the primary factor in determining the outcome, and for which the player may be awarded a prize or thing of value for a successful outcome. So it's a large definition. And one change that's more or less what we had during the session law. But on line 10, you'll see the insertion of the word primary. We want the primary part of the game being the skill. And so that word primary was an insertion. Because we changed that definition, you'll see some language in here where we're going to give the current people that have their machines plugged in a little bit of grace to go back, get another lab report. Because we did tinker with this definition, we want labs to re-review it, but we don't want them to necessarily have to shut down their games when we pass this law, if we pass this law. So there, we'll talk about that later on. You'll see that, but I just want to put that out there as a placeholder. And then on line 13, you'll see skill-based amusement games shall not include any game played for prizes of nominal value as provided by the rules of the commission. And this is what's a concern because of those claw machines that you may see that come down and grab stuffed animals, arcades that actually kick out tickets. As I mentioned, I think most people are comfortable with the concept of an arcade machine, but once you get tickets that are kicked out and you can take it to a counter for a prize, we wanted to be clear that that's not our intention, is to regulate those as we would these skill games. Any questions? Okay.
Mr. Vice Chairman. Thank you, Mr. Vice Chairman. So why the necessity for the word primary?
Mr. Chairman, I think it gets to that concern about what's happening inside the game. We want these games to be fair for the player. And so the idea about, I think, Wyoming feeling comfortable with them is that the outcome of the game is determined by the player's skill, not by the random mechanics of what's happening inside machine, which tends to be more like gambling and having no control over the outcome.
Mr. Chairman, so is the lab report, do they have a way of defining primary as defined?
Mr. Chairman, I believe since we've been working on this legislation, and that concept, I believe, was worked on in the interim, I haven't heard any concerns from industry who have, my hope is that, and they could probably answer this better than I, have reached out to their labs to kind of see, if their machines would still comply. But that might be a question that's better addressed by someone in industry. So far, we have not heard concern that the insertion of that word would cause a lot more, or would prevent operators from losing their games. But I don't know that for certain.
Thank you.
Madam
Okay.
Chairman, please.
And then on lines 17 through 19, you'll see here the definition of a vendor, which is a new concept, but it's not a new concept, just a different word for it. The vendor is a person who owns and distributes a skill-based amusement game to an operator for a profit. Moving on to the bottom of page 17, here's just let me take a look. Oh, this is a new concept. So this talks about the Gaming Commission and what they're looking at. So if you go on to page 18, the initial language said the commission is authorized to access criminal history information for all the licensees under this section. This strengthens it up a little bit more. We want the commission to shall access the criminal history information for all operators and vendors under chapter 3 of this article. And so that was a concern I had. We don't want the commission to say, okay, we've looked at it, but we're going to improve them anyway. And so I think that this is a significant tightening up of making sure we're not giving licenses to people with criminal background records that would that would damage the integrity of play in Wyoming. Moving on, the rest is a conforming amendment dealing with the disposition of fees, just seeing the inclusion of new paragraphs, renumbering. Going on to page 19, I'll classify these as conforming amendments under our tax statutes and licensure boards. Or actually, those are licensure boards, my apologies. Going on to page 20, same thing. On to page 21, same thing, just the inclusion of that. You'll see that statute 1125-201. Going on to page 22. I went through that fast, but please take a look. They're all conforming amendments in my view. Page 22, here you're going to see the creation of section 3. And this says that any person who by the operation of this act is required to reapply to the Wyoming Gaming Commission to retain a permit or license or any other authorization, that they have 6 months after the effective date to have that work completed. This goes to the fact that we changed the definition of skill-based amusement game and inserted some of those extra qualifiers about the claw, about the skill being the primary factor. This assures that if your machine is plugged in right now, you've got 6 months to go get a new lab report to ensure compliance. And then section 4, this deals with re-reviewing the denied applicants from 2020. And so section 4 would require the Gaming Commission to go back and look at those applications, but with these new standards. As we said, they did not apply the notice and hearing requirements under the Wyoming Administrative Procedures Act. And so this would require them to do that. And so going through the language, you'll see that the review shall be conducted on page 23 for any application submitted to the commission, regardless of whether the commission determined the application was incomplete or failed to meet deadlines imposed under the session law. One thing in one of the cases we heard I think it was the Campbell County case, was a bit of the timing issue. In one of the cases, I think it was the Laramie County case, the commission had a lab report. They requested supplemental information. The supplemental information came after the deadline, and then the commission denied it on that basis. We did hear testimony that in some of the instances, or excuse me, in some of my conversations with the denied applicants, we were in a pandemic last year, and there was difficulty in accessing some of the machines because of establishments being closed. And so rather than fight in the minutia, we were, dealing with an extraordinary event. We thought it would be better to just offer a little bit more grace. And so this would allow the commission any information they received prior to May 31st, which was about a 2-week kind of buffer to consider those applications and all the materials that were submitted in that time frame. And then making it clear that when they re-review these applications, that the applicant doesn't have to submit a new application fee. And that's it on section 4. Section 5 deals with your renumbering, and then where their representatives, section 24, this would repeal, section 6 would repeal the session law. And then on section 7 would provide for your effective date. So it's a big bill. A lot of it's codification of what we worked on. There's some new ideas in there. Happy to answer any questions.
Okay, members of the committee, either committee questions for Chairman Ellis? A lot of work.
Thank Mr. Vice Chair.
Representative Sweeney.
Thank you, Mr. Vice Chair. Could I go back to page 18, line 2, where we've added the word shall? So does any of this, these changes apply over to parimutuel and in all of this, so that I know the skill-based games are an addition to the Gaming Commission. But to be fair, will this all be part of the same rules that historic horse racing and parimutuel follow?
Mr. Chairman? You raise a great question. Because this bill deals with the creation of skill-based games, it is limited to just Article 3, which it references, and that's where we created the skill-based, the placeholder for the skill-based games. The parimutuel, I think they would still be probably authorized. I haven't looked at that particular statute and what the requirements are, but there is not just disparity in that issue. I think that our interim work will be, again, kind of reconciling how things work with the parimutuel events and historic horse racing machines, and at least flagging and identifying areas where there's a disparity and having that discussion about whether or not the shall be required for those types of applicants and events. So again, don't let perfect be the enemy of the good. There's a lot of good work here. I can tell you, I think we have a lot more work ahead, and I think that that's one of those issues, is really understanding what we're requiring of skill-based, historic horse racing machines, and other activities that the commission oversees, and just making sure we have a lot more uniformity. Certainly I think that the tax that we impose on skill-based games are different than the historic horse racing machines. We have a lot of those issues that we need to sort out. The challenge was, how much of that do you bring during the session? And coming in as the new chair, I did not work on this last year, but those are things I'd like to work on going forward.
Thank you, Chairman Ellison. Chairman Flitner, it's a little bit of an anomaly where this is certainly in your committee realm. We'll be hearing the bill, but would welcome any amendments that your members of your committee have, as it is irrelevant, and some of them were probably in the discussion. And so if there's any amendments that you guys feel are appropriate, if you could maybe funnel them, we'd be happy to bring those forward. I think, Chairman Ellis, thank you. Would appreciate if you have the time to join us. I think what we'd like to do, Mary Lee, is if Commissioner Moore is with us today, to bring him on.
One final comment, Mr. Chairman.
Please.
I just want to thank Representative Walters. I know he has been a leader on this issue in the House. I've called him, I've emailed him, I've had lots of questions and conversations with him. So my understanding is he's been very involved and he's provided a lot of leadership on this issue and has been really good to work with so far. So thank you, Representative Walters, for being patient with me and answering my questions.
He is a good guy.
Thank you.
We agree. We agree. Yeah. Okay. Chairman Moore, is that you we see? There you are. Or Commissioner Moore, Chairman Moore, Commissioner Moore, Director of the Gaming Commission. Would you welcome, and we appreciate you being here. Could you just give us maybe just a brief, I did say brief, summary of kind of how this has gone for you in the last year, and then we would like a little more in depth your opinion on the impact that this bill, if you think this bill's moving in the right direction, and also any maybe places that we've missed that you think that we need to address.
Thank you, Chairman Larson and committee members. I appreciate the opportunity. My name is Charles Moore. I'm the director of the Wyoming Gaming Commission. With me today, I have my senior accountant, Mr. Steve Dobby, with me as well today. The experience over the last 10 months, 12 months has been interesting, not only with COVID, but with House Enrolled Act 95. One thing for the record, I'd just like to get out there a few things quickly, is I don't gamble either. I've never been a gambler. I gamble when I get up in the morning and head to work. But, you know, we do appreciate everything that you all are doing there. As far as one of the lab reports in part of that discussion, and I don't need to get too far into it, in the labs, there are 4 or 5 laboratories out there that are working currently. But during the pandemic, we ended up finding that the lab that we primarily use for the historic racing would have been unable with the pandemic to do the reporting and review of these game themes. So we went with an alternative group that we did review, and we did do background on, and they provided the lab reports. One of the things early too, again, if you don't mind, you're talking about the age restrictions across the state. And again, referencing the gambling report, the study that I did for you on page 35, I talk about the consistencies of gambling, the age requirements across the state, and you can look at that for future reference. The lab reporting has gone well for us. The questions and the concerns we had with that situation was the failure to provide a report. And again, you know, looking at the session law, translating that and working through that was difficult. Is also with the denials and anything that we're doing through this whole process, because we had a short window, and also with COVID, I had a couple of my employees at the time that were even on leave because they were unable to, they had gotten sick and things. But we were under the direction of the Attorney General's office through this whole process. We worked very closely with all the staff at the AG's office to make sure that we were doing this appropriately and getting those out. Again, the process was tough. We had a 60-day window to basically throw a rope around the skill-based amusement game world and get them reviewed, considered, out the door. We did have denials, and absolutely correct. We do have 3 of them that are on administrative appeal currently. So they're going through the process, and they were afforded their due process through that. The bill, I think there's some great pieces in there, and I appreciate the amendments that are brought, and I appreciate the hard work that the senator has put into this trying to bring this up to speed. And, you know, it is a challenging world that we work in. And, you know, just to show you, and you probably can't see this, this is a gaming report, 300 pages. And to a little bit clarify some of the things, I spend each day and have for the last, well, probably since 2014, reviewing laboratory reports along with my staff almost every day. So there is a lot that goes into them, the nuances, the different things, and we rely heavily on our communication with the laboratories and their expertise, and then put it together with our expertise that we have here. So it is a lot. The process has been not the easiest process, but we are making headway, and I think the bill does address a lot of the issues that we've had. So, and also too, there's the interim committee has worked very hard this summer with the amendments. A lot of those amendments were amendments that the chairman on the Senate side he had me work with LSO on that for those amendments. So I stand for questions, I think, at this point. Thank you.
Thank you, Charlie. Any questions for Director Moore? Representative Stith?
Mr. Vice Chairman, Mr. Moore, question, how do you feel about whether the laboratory reports are submitted directly to you or whether they're provided to you by the applicant?
Thank you, Chairman, Representative Sith, excuse me. The lab reports, you know, it's working the way it is. It's currently working fine. You know, one thing, and I'm glad you asked, how the process works in real life is I get an email, and I get multiple emails every day from the laboratories, whether it's Eclipse, whether it's GLI, whether it's BMM. We're receiving emails daily on lab reports. Typically, the laboratories do consider the regulatory jurisdictions as their client, even though they are being paid. So it's working the way it is. We ask the clients, the vendors, operators to submit their reports to us, but at the same time, the laboratories are also sending those via email, and we have access to their web interface where we can go in there and pull those reports and reference old reports, new reports, so they're all there. So, you know, I think it's working well at this point. So I hope I answered your question.
Representative Harrelson?
Thank you, Mr. Chair. Commissioner Moore, one real quick question for you. Obviously, you guys kind of got saddled up with a whole bunch more work with these skill-based games. Is the 10% of the gaming accounts, those fees, is that going to be able to offset what it's going to need for your staff to be able to handle this increased workload?
Director?
Thank you, Chairman Larson. Representative, I appreciate that question. Yes, I do believe it is. I think that's sufficient at this time. We are currently in the process of delineating out exactly our expenses that we are focusing towards skill-based amusement game versus live horse racing versus the historic racing. So I think at this point, yes, it is a good spot.
Representative Walters?
Thank you, Mr. Chairman and Director Moore. What is the ability, would you say, of the commission to disregard the findings of a lab report, or essentially make a decision or your own determination of what the quality of a game is versus what the lab report might be telling you?
Chairman or Vice Chairman Larson, Representative Walters, again, another good question and a very difficult question. We review the lab reports. We also work with the vendors and review the gameplay. We have several games here also in the office, and we go through all their documents and review those. And as far as some of the denials, again, It was just strictly a failure to provide the report. Very simple. No lab report provided. We can't make any kind of a judgment call at that point because we have none. On some of the lab reports that we went a different direction from what they had, they weren't necessarily contemplating, and their lab report also stated in there that they were not the last person. It was up to the state or the regulatory jurisdiction. And I don't have the language in front of me, but there's the disclaimer in every one of the reports that does talk about that. The ultimate decisions typically in the lab reports are up to the jurisdiction. I'm not sure if I answered your question.
Follow up then, if there's some odd language within and I shouldn't even say odd language, but something within a lab report that's concerning to you, do you ever ask for a second lab report or another lab report to try and have things clarified to make sure the validity of the games?
Chairman Larson, Representative Walters, yes, we do. We also communicate with the laboratory and with whether it's historic racing, whether it's live horse racing with the terminals at the racetrack and the technology. We communicate constantly with the laboratories to get more verification.
So Director Moore, I would follow on to that. Is you indicate that you feel that it's working currently as it is, but we've heard testimony that would suggest otherwise. Mm-hmm. And so I think as a result is why you see the new language in the bill. Does the new language where in the bill, and you point out that the reason for denial was there's no lab report. Could that have been confusion that lab said didn't know to send it directly to you, or did they send it directly to the vendor who then thought they needed to send it directly to you? It sounds like we have some confusion in that regard. And so with this new language that then requires the operator or vendor, and I may have my terminology mixed up there, send that directly to you. Do you see that as somehow detrimental or diminishing the integrity of what you're trying to accomplish?
Chairman or Vice Chairman Larson, again, thank you. I think the language is fine also that you have here today. It'll work, and I don't really see a problem either way with that. As far as the confusion, I think it was absolutely crystal clear, no confusion whatsoever. It wasn't because the vendor or the operator or the lab was confused who to send it to. It was strictly, there was not a report available that contemplated House Enrolled Act 95.
Chairman Nicholas.
Thank you. So, Director, I've got a couple different questions, but my first is, I'm curious about, because we took the pari-mutuel and converted it into the Gaming Commission. And so that the Gaming Commission is kind of, by definition, kind of stacked with horse racing people on it versus other expertise. And so my question is what is your thinking on whether or not we should perhaps modify the makeup of the commission to make it a more balanced in terms of all the functions that you do?
Director Moore.
Thank you. Vice Chairman Larson, Representative Nicholas, if I can paraphrase it back to you, I think, are you talking about the commissioners or the commission staff, or are you talking about both?
Oh.
Thank you. Commission staff, first of all, we've been dealing with gaming and gaming related issues since for several years with historic racing. Historic racing is very complicated. In fact, you get into the gaming world and you talk to people, they say we would much rather be dealing with other issues. With the historic racing, it's a very complicated process with the wagering on the old horse races. So we've been dealing with this for a number of years. Again, initially when historic racing came forward, one of our goals, and if you look at our mission statement, our new mission statement, and I don't have it in front of me right at this moment, but one of those things states in there to be a leader in the industry. Currently with the horse racing side in the historic racing, it's in a small number of jurisdictions, and we have led the way. We've led the way in review process. We've led the way in testing. Each and every game that's out there in the state receives quite often signature reviews to make sure we have the right software. But then we also have an RFP and a contract with Gaming Laboratories, Inc. They come in once, twice a year and verify signatures and verify that. And also too, we've worked with Gaming Laboratories, Inc. as far as our rules and regulations, as far as keeping those and getting those up to speed with other gaming entities. So to answer your question, I think we need more staffing. I do have currently that we are moving forward to fulfill a B11 to add additional staffing here in an AWAC situation, and I fully understand how that process works. So I'll be back to see you in the fall with that in my budget. But we do have that opportunity, and thank you to the governor's office and budget division. But as far as the commissioners go, absolutely correct. A lot of the commissioners we've had over the years and often are more attuned to maybe the horse racing side. However, I was asked several years ago, what's the optimum person to have on the commission? And I said, just a good-minded business type person. And that's what I do like to see, because, they can learn the process. I think the commissioners we have now have really stepped up to the plate and want to step up to the plate even further in the future. And I also appreciated hearing some of the comments yesterday in the Senate hearing from one of our potentially new commissioners wanting to really get up to speed and work very hard in this. We've also, as far as the commissioners have been concerned, again, for the last year, we've been on basically a no out-of-state travel. It is up to the discretion of the office, but most everything that we've had opportunities for training and education have moved to the virtual format, which we participate continually with that. Back to an original question that was asked, and I'll catch it right now if you don't mind, Representative Nicholas, would be the skill-based amusement game operations in the state have been very helpful through this process. It's been a good process with them. There's no way we would have, without the cooperation of all the individuals out there, we wouldn't be where we are today with the revenues that are being generated. So I did want to say that.
Thank you. Representative Winters, please. Representative, before, let me just acknowledge that Chairman Driscoll, welcome. Glad you're here. Thank you. Representative Winters, thank you.
Yes, thank you, Mr. Vice Chairman. Director, my question is, does the commission have the capability or the expertise to conduct spot checks during the year on these various skill games that are in use at the time?
Director.
Thank you, Vice Chairman Larson. Representative, you went off the screen. I'm sorry. Well, so I couldn't catch your name. I apologize. Winters, excuse me. Yes, we do. Absolutely. Our two investigators even are out in the field constantly. I do have another inspector that we're hoping to pull on board here in the near future when we get the job posting. But yes, we have put a lot of miles on the state of Wyoming vehicles, and we will continue to. Our two investigators are all over the state verifying. And then, like I said, we do have Gaming Laboratories, Inc. that does come in periodically and do signature checks to where we make sure we have the appropriate software installed on everything. And if, in fact, the sunset is removed on this and we move forward, I would expect the commission would do the similar things with all gaming devices in the state, whether it's historic racing or whether it's skill-based amusement games.
Additional questions?
Just a quick follow-up on a separate topic. Obviously, we didn't realize that you were listening in yesterday, but in terms of the sports betting, do you need any other personnel, or how are you getting set up to be able to manage that in on your bag of tricks?
Well, thank you, and Vice Chairman Larson, Representative Nicholas. Yes, I was, and thank you for acknowledging I was on the call last night. I was prepared to speak if you needed me, but as it was, I didn't have to. But again, and I did send to LSO staff last night during the meeting. In the gaming report, we talk about the sports wagering in different things, but also in the gaming report, we talk about additional staffing levels. And I've been very fortunate to know for several years the director of the sports wagering at the Department of Revenue in that state to the south of us. And he and I have communicated directly quite often. In fact, I sent off some questions to his office this morning as far as sports wagering goes, and expect a response here in the near future from him. We will need additional staffing, obviously. One of the things that did come up in your discussion last night, I think there's some outside vendors that could be contracted with to do some of the work. So that was something that I hadn't even really thought about. So I did appreciate hearing that discussion. So yes, it's again, in that state to the south of us, I believe they have 9 people working there in their office when they staffed up. Obviously, we are much different here in our great state. We work hard and we can do it with a little less, or a lot less. But yes.
So then what, Charles, what I think the JAC will want is to get your updated books, your employees, staffing levels, what your balances are on your accounts that we set up for you last year in order to fund the whole operations and your monthly expenditures and that kind of stuff. So we can get a better picture of that. And then we'll know it. And then also if you have estimates on what that 10% is going to approximate from these machines also, just so we can have a better idea of your operating costs and income coming in and going out. Thanks.
Absolutely. Thank you very much. What type of time frame, or excuse me, Vice Chairman Larson, what type of time frame to get that to you?
Oh, let's see. It's about 1:40 now.
Well, Chairman Larson, I can have it to you right now if you want to run down through it. I've got it right here. So
why don't you get that to the chairman and he'll get it to us as best you can, please.
Thank you very much. Appreciate it.
Any other questions for Director Moore? Representative Harrelson, please.
Thank you, Mr. Chairman. One thing I'm going to go and beat on a dead horse here, and sorry, that's a pun for you guys with your background with horse racing, but we have the laboratory reports. If we were to, I go back to the concept, is there no concern about the fact that the vendor submits the report or not? I guess I just don't want it to be a situation where we see something come forward that could be fraudulently put forward, or especially if we're having an issue getting lab reports that they don't produce their own, or I just want to make sure that that's good. So like an idea possibly moving forward, could the laboratory report be submitted in a dual purpose where the vendor gets a copy as well as the commission gets a copy? That way, if for some reason the copies didn't match, there could be a question brought forward. I don't know, just a thought. I wanted your opinion on it.
Director Moore, so that then follow up, I think we kind of asked that question. If the process, we've talked about the process you currently have and the process is recommended in the bill. If you see a problem, you indicated you didn't see a problem with where we were at. We talked a little bit about the process outlined in the bill. I think that you suggested that you were comfortable with what was outlined in the bill, but if you have any feeling contrary to that and that comes to light with Representative Harrelson's questions, that would help us.
Thank you, Vice Chairman Larson, Representative Harrelson. Actually either way works. The reality of it, and I am comfortable what's in the bill. The reality of the laboratory reports is we always have access to the original via the web portal with the labs. Again, that's in dealing with the larger labs, the 4 or 5. So it's not a problem. Again, the labs that we're currently using and we currently have authorized, I have that access. So if the reports are there, we get them. So I'm fine with it either way.
Thank you, Representative Harrelson. Director Moore, thank you. Appreciate your time. So, folks, here we are. It's about 1:45. We check in back at 2. This meeting today was really to help the Appropriations Committee, who's going to be working the bill, get our head around the history of it and what's taken course over the interim, prepare us to then have what I would consider to be kind of a standard committee meeting where we would take comments from industry and providers and those impacted, the public as a whole. If there is somebody here that if there's just something that you're going to die before you get out the door if we don't hear it, we certainly, yeah, we would certainly provide you that opportunity, but just trying to maintain some sense of standard procedure. We want to afford everybody that opportunity to hear that. We'll be bringing the bill. It'll be posted for hearing. So
Yeah, and just for everyone's edification, but we've got a lot of things to do in the next 3 or 4 days in appropriations. And so what we're going to do is we'll take the current bill and we'll work it, but we're going to work it fast. We worked this bill last year, and so most of us are pretty familiar with what's in it, and we understand it. And there will be maybe some differences of opinion of the committee members on whether or not we open this up to more games and more establishments or not. Those are policy issues. But in terms of just, what I'm saying is if you like what's been done so far and by the good senator from Cheyenne, then all you got to do is tell us you like it, because we've got lots of bills on our table, on our tab, and we're going to pass this thing out as quickly as we can. And so we're going to need your assistance to get it done quickly. So I think as a practical matter, we're going to adopt almost everything that we've seen. And the same with you folks. If you have particular issues, just please let us know, but we're going to run this thing through pretty quickly. Just so that we can get it to the floor, get it to the body, and then get it out of our committee. So, all right. So hopefully that helps. Please, go ahead.
Chairman Ellis.
Mr. Chairman, just in case I can't join you for future discussions, just a couple of things to add. Back to the lab report being directly or not directly. A big part of my concern is just kind of the treatment of all the applicants, making sure it's fair. I suspect that there were other applicants whose applications were approved that they didn't receive those lab reports directly from the applicant, but their applications were approved. If you read the court cases, there was an applicant who was late. She submitted incomplete information, trying to explain to the commission that, there were some COVID circumstances. She was trying to get all her information and it was difficult. And as a policy maker, and which we all are, I look at the work that we did during our special session, bending over backwards, trying to provide relief to people who are struggling with making ends meet during COVID. And so that's why there's a little bit more grace I'm trying to ask for in this bill. You heard the commission, this bill passed on March 17th. That was the day that we started shutting everything down. So they were in a huge hurry to try and figure out how to start implementing this statute. Businesses that wanted to come online and apply had to figure this out, all while, our kids are closed, our businesses are closed. And so some of these changes are really an effort to recognize that we went through something extraordinary at the time that this enactment happened. And so, when it comes to the lab reports, I do have concerns about the commission's discretion to make individual determinations and how they did that. In one of the cases I read, and if you go back and read the minutes, and I know Representative Walters lived most of this, the denial was done through a letter and with one word sentence. We looked at your lab report and we say, we don't think it's okay. And so if you're an applicant, of course you want to know why, and you want to provide an opportunity to say, we disagree, let me show you this evidence. But digging into it a little further, my concerns are rooted in the fact that, in one of the cases, I didn't read the reasoning until the Gaming Commission's attorney filed it in court with a reply brief in one of the cases. And when I read it closely, they looked at a theory of why the game they didn't think meant skill-based, but their theory, I'm concerned, undermines the whole premise that upholds historic horse racing machines. And so I think right now we really need to rely on these lab reports. And we're not saying that the out-of-state labs have this decision-making authority, but unless and until this commission gets really up to speed, develops clear rules so that we know what the playing field is, I think that's the important step. Are we there today? Are we going to be there in 2 months? No, that's going to take some time. So I just want to make it clear. That's why there are some of those changes. Removing that word directly, I think, puts those denied applicants on much the same level playing field as the other applicants who are going through or got approved when they applied. And so that's a lot of motivation, is to try and recognize that we have some cleanup to do, and hopefully we'll do a better job going forward. And that's not to disparage people who worked on this bill before, but
Mr. Vice Chair,
there's a lot going on.
to follow up on that, I think that it was never anybody's intention that there would be components of this that were not going to be following the APA. I mean, these are businesses, they're licenses, and so they should always have the ability to have a review, have a record to review, and have findings of fact and conclusions of law on why anything is denied or not denied, and a timely opportunity to appeal. And so if regardless of whether or not an AG says, well, we don't have to, we don't want to play that game. We want to ensure that, and this is for you, Director, that you put in your own rules that you'll comply with the APA, and that you will always make findings of fact and conclusions of law, so that and there's a sound basis. With regards to these lab reports, the rulemaking process will allow you to establish who is authorized to do the reviews and what information you want in those lab reports, so people know what those lab reports are supposed to look like. And so you make it easy to do business and make it fair to everyone there. And so if that's not happening, then that needs to be fixed. And so we'll continue to monitor that, and I'm sure you will too. So
Thank you, Mr. Chairman, but hopefully that answers some of the reasons why I feel very strongly about that word directly being removed. I'm just trying to level the playing field.
Mr.
Representative Sweeney, quickly.
Thank you, Mr. Vice Chairman. So my biggest concern, which I think has been answered, is the sunset date. And so in the appropriations process and working the bill, If there can, that sunset date, by the end of the time period that we work this bill, that will be alleviated because we will have completed this if the body votes on it.
If we pass the bill, then it will carry forward from the sunset date would not take effect.
Okay, thank you, Mr. Chairman.
Thank you. Okay, Mr. Chairman, with your blessing, chairmans, they turned their back on me, so we're going to call it good.